Members, this is the appointed time. We have a quorum. So thank you for attending the meeting of the Bills Committee on Construction Safety Security of Payment Bill. We're going to have two meetings today. The next session will begin at 10:45 a.m. in this same room. Let's invite the administration to come in.
Good
morning. Welcome. Now we're going to discuss the issues arising from the previous meeting. The administration has given us a response to issues raised at the meeting on the 16th of July 2024, and that's CB bracket 1 1296/2024 bracket 02. The administration has also given a response in writing to the submissions received by the written committee, and that is CB bracket 1 1296/2024 bracket 03. I will invite the administration to walk us through the response papers. Since we all have those papers, please be succinct. Who would like to start? Permanent Secretary. I thank Chairman and members for supporting our work and giving us invaluable views. We have issued two papers. The first one relates to members' concern when it comes to one of the parties being bankrupt and whether the next lower tier party could invoke the conditional payment terms in contracts such as pay when paid contractual terms. The next paper relates to our response to the written submissions received by the Bills Committee. I'll say a few words and then I will give the floor to Mr. Johnny Chan to walk members through the paper in greater detail. Now, on the last occasion, members were concerned that when one of the parties becomes insolvent, whether the next lower tier party could invoke the pay when paid contractual terms so as to demand payment. Well, I hope members would understand that the purpose of the bill is for the receiving party to receive payment upon completion of works. In other words, even when the upstream contractor or the subcontractor go bankrupt, there should not be such prohibitive clauses in the downstream contractors. That means even when the upstream contractors or subcontractors go bankrupt, the downstream subcontractors will still be eligible for payment. We've looked at the practices around the world, and this is in line with the international practices. Now, at the public hearing, we understand that there is general support for early passage of the bill, and the Bills Committee has also given us invaluable views. We also have the industry's consensus for early passage of the bill. So we'll continue to liaise with the industry to facilitate the implementation of the bill. And I will now, without further ado, give the floor to the Deputy Secretary to brief members on the two papers. And then I've also prepared a PowerPoint presentation for the clause-by-clause scrutiny at the next stage. Mr. Chan. Yes, let me first explain our response to members' concerns at the last meeting, and that is the pay when paid contractual terms and how it applies when, in the case of bankruptcy of an upper tier party to a contract. Now, members were concerned that when an upper tier party to a contract goes bankrupt, the lower tier party had to bear the financial burden of paying the next lower tier party even when it could not receive payment, which might affect the different tiers in the supply chain. We want to emphasize that we want to address the situation of long-standing issue of delayed payments in the construction industry supply chain. However, in the case of a contractor declaring bankruptcy, this case falls under the ambit of the Companies Winding Up and Miscellaneous Provisions Ordinance, and the repayment of debts through liquidation should be conducted according to the mechanism under the ordinance. And according to our industry consultation in 2015, most industry stakeholders supported the prohibition of pay-when-paid clauses in downstream subcontract agreements, even when there is bankruptcy declared on the up the stream. Now, if pay and paid clauses remain effective in downstream contracts, even when, well, Deputy Secretary, just be brief because we have the paper in front of us. You don't need to read it out. Well, this will go against the fundamental principle of this bill. Usually, the claiming party in upstream contracts possess better financial capability than their downstream counterparts to guard against and deal with the impacts of bankruptcy. This bill will assist parties by reducing disputes, and if payment disputes are resolved promptly, there will be fewer or less financial pressure on downstream subcontractors. We'll also consider assisting the contractors and subcontractors owed money by a bankrupt party to swiftly receive payments during the liquidation process through adjudication. Now, there are countries adopting this approach, and members asked the government for further details. We've made reference to the practices in these countries. We believe that these countries adopt the most suitable approach for their payment security laws. Now, for the UK's construction industry payment security legislation, they've considered that the insolvency exemption clause is a compromise reflecting the practical considerations. Now, whereas for the Islands Act, it has a similar approach, exempting insolvency in its prohibition of the pay-when-paid clauses, but we have yet to identify the rationale behind the exemption clause or any review conducted by the government. Now, whereas for other countries such as New South Wales, Australia, New Zealand, Singapore, they do not allow enforcement of the pay-when-paid clauses, even in the event of the upper tier contract parties going insolvent. In fact, in 2017, the Australian government conducted a national review, and it stated that the pay-when-paid clauses should remain prohibited. The rationale is that this is inherently unfair. During our 2015 industry consultation, most stakeholders supported this blanket ban, and that no exemption should be given for insolvency of certain contract parties. We believe changing the proposal at this stage would trigger a new round of disputes, which will hamper the passage and implementation of the bill. Now, as for the next paper, it's rather long. I'm going to briefly summarize the 5 salient points. First, scope of the bill. The bill currently does not apply to large-scale maintenance projects of existing private residential buildings. We note that some wish for the bill to cover these projects, but others understand and support the scope of the bill. We believe it is therefore it is important that the bill is passed as soon as possible. In fact, in August and September, we met with the property management sector. The meeting was conducted between the sector and the task force for the preparation of legislative proposals to the construction industry security of payment legislation. It is believed that an appropriate balance between improving payment issues faced by the construction supply chain stakeholders and avoiding impact on the public and SMEs has been achieved. And we've also explained the rationale behind this arrangement. For example, owners may not be able to comply with the strict time requirements stipulated in the bill's adjudication procedure, and that suspension of works in private residential buildings may pose safety and hygiene issues for residential owners and occupants. And it is believed that maintenance projects for private buildings are usually simpler with fewer subcontracting layers and fewer payment disputes. In fact, the property management sector also expressed that additional burden and impacts may be brought on to owners by the bills payments and adjudication time frame, as well as the right to suspend works. That may also hinder owners' willingness to renovate old buildings. So we do not recommend including private residential buildings in the scope of the bill. We'll continue to listen to views. As we explained earlier at the public meeting, as long as the main contract of a site is valued at no less than $5 million, then various types of contracts involved, including landscaping works or self-employed lorry drivers, whether signed and whether it's written or oral agreement, will be protected by the bill, even if the individual contract value is less than $5 million. Next, improving contract payment terms. There are some who suggest amending the maximum payment period from the claimant submission of a claim to the payment being made from the currently proposed 60 days to 45 days. There are also suggestions of including an independent payment certification mechanism. We need to consider the actual operation of the industry. According to the industry consultation, there is consensus of the 60-day payment period being reasonable. As for the retention money, the purpose is for remedying defects and deficiencies during the maintenance period. The purpose and function of retention money are not to replace the main contractor's payment to subcontractors. As for the next point, the main contractor and subcontractors would usually employ professionals to prepare payment certificates and review the amounts, and if need be, they can hire external professionals to assist in the process. And there is also an adjudication mechanism provided in the bill when there are payment disputes between contractual parties. As for the lengthy settlement process, there are suggestions that a deadline should be set for account settlement. In fact, members raised a similar issue in the previous Bills Committee meetings. When handling the settlement of accounts, the claimant and the payer will need to analyze all claim amounts, including additional amounts for extra works. In some contracts, it may involve a long processing time. We considered that we have an adjudication mechanism setting out the payment period and payment response period. As for the claim handling procedure, it will have to be done in a reasonable manner. Now, if there is any dispute, either party can request adjudication to resolve the dispute. If the payer does not complete the claim handling procedure within a reasonable time frame, they can turn to adjudication. The bill encourages early resolution of mid-contract disputes and improve stakeholders' cash flow in the supply chain and reduce the time required for account settlement. Not to mention that we're currently promoting new engineering contract, and under this model, parties might consult on disputes within its specified time frame. This can reduce the time and the chance of disputes and shorten the time required for account settlement. Now, as for the other point about the prohibition of the conditional payment terms, this point has been covered in the first response paper, so I'm not going to repeat it. The next point is about adjudication mechanism. There are suggestions on having more adjudicators, shortening the time frame for adjudication, including more clauses. The purpose is to provide a fast and binding interim dispute resolution mechanism. We have made reference to overseas payment protection legislation. We have also considered local industry stakeholders' opinions. Now, in the adjudication process, independent professional may be engaged. It takes time to go through the adjudication process. We have introduced deadlines to ensure smooth completion of adjudication without additional expenses. There are also safeguards against abuse. Members may wish to refer to the paper for details. There are comments on the qualification of the adjudication bodies, the time frame for nomination, etc. Well, as discussed, apart from drawing up the code of practice, the fees for adjudication will also be capped so that it should be within an affordable range for all parties. There is also a suggestion that the bill should cover payment disputes related to extensions of time in private construction projects as soon as possible. Usually, adjudication over EOTs is more complex. It takes time to train a sufficient number of adjudicators with relevant experience. So we propose a phased implementation of adjudication involving payment disputes over EOT as a more prudent approach. We are going to publish in the Gazette in a timely manner for the implementation of the bill in private construction projects, and we'll also review the implementation in a timely manner. When the industry is ready, we will extend it to the EOTs or the payment disputes over EOTs in private projects. There are also suggestions that to prevent downstream contractors from abusing the right to suspend works, the bill should consider only allowing the first-tier subcontractors to exercise this right. But if we limit the downstream subcontractors' right to suspend work, it will reduce the effectiveness of the adjudication mechanism to ensure timely payment to them. There are also suggestions that work suspension can only reduce losses and it cannot effectively recover debts such as adjudication, determination, and the amounts to be awarded. Now, the purpose of the adjudication mechanism is to resolve disputes, allowing the claimants to receive the payments is one way of resolving the dispute. It is not a means of punishment. The adjudication determination will put pressure on the payment party. The claimant can also apply to the court to enforce the adjudication determination to obtain their entitled payments. The application process is simple. The court generally grants this application within 7 days. Last salient point is implementation of the bill. There are suggestions for the directors to be empowered to extend the 8-month effective date However, most industry stakeholders would like to see the early implementation of the ordinance, and we also need to carry out necessary preparations such as training adjudicators, approving institutions to be nomination bodies, and establishing the list of adjudicators. After discussing with the groups and the task force, the stakeholders in general agree that the current 8-month period for the effective date of the bill is appropriate and feasible.
而家咧就
Thank you, Chair. That's it from me. All right. I've seen several members who have pressed the request to speak button. I'll have a 4-minute time limit for each member. Mr. Chan Siu-hong, thank you. I want to follow up on what we discussed on 16th of July and the administration's response. The bill wants to prevent the abuse by upper-tier parties of the pay-when-paid provisions. We have also talked about some unlikely scenarios where the upper-tier party may go bankrupt and the middle-lower-tier parties still have to pay the lower-tier parties. They will be subject to a serious financial burden. And it was said earlier the UK and the Ireland would allow for an exemption in this scenario. So I'm thinking whether we can enhance the arrangements in the UK or Ireland to deal with this scenario. We need to make sure there is a mechanism in place to deal with this scenario so that, for example, when contract A and contract party A and contract party B and contract party C, we don't want to have a domino effect where the contract party C, which is the lowest tier, would not be paid. And we don't want to see a domino effect that the whole chain will be affected when one party goes bust. So I think we should refer to the practices in the UK and Ireland. But of course, I understand that the industry has different opinion, those in the industry. I know that some would want the bill to be enhanced, but some are also concerned that we should not delay implementing this any further, and they understand that the bill may be imperfect and we should just review the bill after implementing it. I hope that I can get a confirmation from the administration that should there be any incidents where a party goes bankrupt in future, there is some way to deal with it. I think the response of the administration is quite detailed, and Mr. Johnny Chen explained this earlier. We have to understand that this scenario is not common. We do understand that different practices are adopted in different places. Should an upper tier party not pay the lower tier party as long as they have a liability to pay? The lower tier party cannot invoke the pay when paid provisions. The principle is clear, and I understand that this has been addressed before. Since the deputy chairman mentions this point, of course you will have to address his views, but I think you can be brief. Chair, I would like to say this. In the response, the administration said there is a consensus, but I don't think that is the case. I understand that we have the bill here, but I want to know what the administration's plans are in future. All right, Mr. Ricky Lau. Thank you. We discussed this earlier in previous meetings. There are many reasons why a company may go bankrupt. And when a company goes bankrupt, we will use the ordinance, the Companies Winding Up and Miscellaneous Provisions Ordinance, to deal with such cases. The member mentioned very clearly earlier, we want to make sure payment is made. And I think when a company goes bankrupt, what the bill can help is that should an upper tier party go bankrupt, the lower tier party, perhaps the middle lower tier parties, they may still have issues, but then their lower tier parties will also be affected. With the bill, we believe it can improve the situation in the sense that the middle lower tier parties will be paid early on by the main contractors so that they will have a better cash flow. Also, there is an education mechanism in the bill. If an upper tier party goes bankrupt, the adjudication determination may help the lower tier parties to make claims for the amounts that they should be paid. We have been considering this, and if we have any updates, we'll report this to the council in due course. Chair, I think the government has the responsibility to make sure works would be completed should a party go bankrupt, and we do not wish to burden those in the middle tiers. So if the administration promises that they will think about this in future, I would be satisfied with that. Well, I think in bankruptcy, there are different priorities with creditors' claims. We have an existing mechanism to deal with that. So for this SOP, if an upper tier party goes bankrupt, whether we should still execute provisions in the bill, the government stance is very clear about this. This is indeed a complex issue. But if we have an SOP, it is believed that it may help the lower tier parties to lodge claims for the amounts that they are owed. I think the government has a very clear stance on this. We should not blindly refer to the practices in the UK or Ireland. And in fact, this exemption is not common in the world. We heard about the administration's justifications. In the bankruptcy scenario, the government is actually more concerned about the fact that there may be a domino effect. Thank you, Mr. Tony Tse. Thank you. I have the same concerns as Mr. Chan Siu-hung had. In the public hearing, more than one deputation expressed concerns about this. I heard what the administration said earlier. But it's not about how many jurisdictions adopt certain practices. It's about what's more appropriate for Hong Kong. And we have heard what the industry thinks. Of course, nothing would be perfect. But let me say this. I understand what the chairman said about the administration's plans are, that is, to review the bill after implementation. But I think it's more ideal to do this before and communicate with the trade to see whether the bill can be improved. We do not wish to see the domino effect that their whole chain will be affected. We have to understand that SMEs face great pressure right now, especially SMEs in the industry. Many subcontractors are facing problems in cash flow. Does the administration have a timeline for when a review is to be done? I know that the administration would do it at some point in time, but if you can give a timeline for the trade for reference, that would be ideal. So I want to know if the administration can provide at least an approximate timeline. What is to be done should such scenario happen to support the lower tier parties? Thank you, administration. Thank you, Chair. We, of course, are concerned about any company in the industry going bankrupt because that will affect the ecosystem, and we are, of course, concerned about the domino effect. We talked about conditional payment terms such as pay when paid clauses. These have existed in the industry for quite some time. And as I mentioned earlier, we have a task force and we have discussed these extensively during meetings of the task force. We have talked about for the upper tier and lower tier parties, the main contractors, subcontractors, or other downstream companies. They had representatives at the task force meetings. And of course, we understood even during the meetings, the stakeholders had different views, and approximately 70% of the stakeholders at the meetings believed there shouldn't be any pay when paid clauses in contracts. So that's why we said that there is a general consensus. And I think we should conform to the basic principle that we should not have any pay when paid provisions. But as I said earlier, we have been discussing some arrangements. And in fact, after we heard what the deputations said at the public hearing, after that we have been communicating with stakeholders and other departments. I will not mention specifically what departments they are, but we'll talk about what we can do should a company go bankrupt, what we can do better, and we will continue liaising with the relevant stakeholders on this. Thank you. Chair, I just hope that this happens as soon as possible because in the public hearing, we heard many deputations express concerns about this, and we do not wish to see a domino effect, as I said earlier. All right, thank you. But I would say this. Personally, I think that for some more complex projects that are of larger scale, should a party go bankrupt, whether the lower tiers will be affected, whether this bill exists or not, they will still be affected. And as the administration said earlier, even if a company goes bankrupt, there shouldn't be any pay when paid provision still. That much is clear. But if there is bankruptcy in the supply chain, there will be a break in the supply chain and there will be a break in the fund chain. And I think the Development Bureau has experience in handling such cases. And the administration has promised that they would review the implementation in due course, but I don't think it affects the SOP in the bill. And let's not dwell on this any further so that we would be impeded in our progress in examining the bill. Thank you. Mr. Kwok Wai Kung, thank you. I think the government's stance is clear. We shouldn't provide an exemption for pay-when-paid provisions even if a company goes bankrupt. I understand the government's stance. I'm actually more concerned about the adjudicator mechanism. It is said that the bill will come into operation some months after the bill has passed because they need to make some preparations for training adjudicators. But how many adjudicators do we actually need? How many do we need to train? I think the government has a number in mind as to how many adjudicators we need or how many adjudicators we need to train. We also have to think about how long the adjudicators need to be trained for. The bill will come into operation 8 months after it is passed. Is this enough? We have to understand that if someone is interested in becoming an adjudicator, they need to take some time to find a course to apply to. It does not happen right away. We need to take that into consideration. Also, I want to ask, will adjudicator training be covered by CEF? If there is some financial incentive, that would definitely encourage people to take the course. So I want to ask if the administration has considered relevant support. Also, has the government liaised with relevant institutions to discuss the curriculum for training for educators? Thank you. Administration, thank you. We think training is, of course, very important. We did not consider only the quantity but also the quality of training. We will make announcements in due course once the bill is passed. We have already been liaising with the relevant professional institutes or an institute. We have been working with the Development Bureau to formulate a curriculum as well for educator training to make sure there is professional recognition. So we will be able to guarantee the quality of nominating bodies. There are several institutes that are very experienced in this. They have 200 members. Is 200 enough? Well, we think there should be as many as possible. So after the bill has passed, in the 8 months, we will do much work. We will accept applications from potential nominating bodies. And they will accept applications for training for those who are interested in becoming adjudicators. We would require the curriculum to incorporate dispute resolution elements, and the courses would have to take at least 1 to 2 months to complete, so the courses would be more comprehensive.
The nominating bodies will provide the training. Those bodies will charge their members where needed. Now, for the Continuing Education Fund, we don't think we should use that for now. So that's all from me for now. Thank you, Chairman. So do I have to wait for the second round? A simple follow-up question is fine. A comment about nominating an adjudicator. So the nominating bodies will have to do that. Should the adjudicators provide a detailed disclosure of interest, or do the nominating bodies do that? Thank you. Now, one of our papers we're working on is about disclosure of interests, dealing with potential conflict of interest. So future adjudicators will have to declare potential conflict of interest. We're also working on the adjudication rules. That will be on the operational details and selecting adjudicators. There will also be a code of conduct for adjudicators to follow. And there will also be practice notes. That document will be on the points to note for future adjudicators. So these documents, code of conduct, practice notes, adjudication rules, they will come on stream in the next few months. Mr. Andrew Lam. The domino effect is a shared concern among several members. I see the government's resolve in this bill. I don't question the government's resolve. Here's my concern. Any new bill will bring changes to the ecosystem. Our discussion has been about responsibility for different players along the chain. Now, I don't expect a perfect answer to my question, but let's take bankruptcies for now. It's about contractual responsibilities. What do we do when bankruptcies happen? And then when we have a new ecosystem, what about joint subcontract? I'm talking about joint subcontract where the responsibility is shared between different parties. The Permanent Secretary mentioned practice notes and code of conduct, but we should think ahead about the details. At another committee, we've been discussing project costs. Now, for players on the lower tiers, those players will factor in the risk premium in the cost. So the government should be closely watching changes on this front. Some companies may take on fewer projects because of the higher risks, so that's something for the government to note. Permanent Secretary. Now, on the point about the new ecosystem, the industry is confronted with payment issues, disputes over payments, and protracted processes. Through this bill, we want to see an improvement in the situation. Now, for payment arrears for more than half a year, lower tier players are under great strain. Some subcontractors are at risk of going bust. The passage of this bill will help. We will see a more robust ecosystem. The member mentioned joint ventures. There are laws regulating JVs. When one party goes bankrupt, the remaining partner or partners will also have to complete the works. So that problem shouldn't be big. Now, on project costs. Now, with payment in arrears for the lower parties, there are extra costs for the lower tier parties in terms of interest and other ways. So the lower tier players built in the cost, and that's the risk premium. This bill will bring in payment deadlines, so the lower tier players will find costing more predictable, and that will lower the risk premium, and this will help lower project costs. Thank you. At our public hearing, we had 50 deputations. There was unanimous support for this bill on security of payment. People are not happy about the current malpractices. People want to see a healthy ecosystem. Mr. Dennis Leung. Chairman, before the bill received its first reading, the government briefed the FTU about this bill. This bill will get rid of conditional payment clauses, meaning pay when paid clauses. Those clauses will be gone. This is a concern among lawmakers from the labor sector. These contract clauses mean our workers do the work without getting paid. They have to wait for the top tier parties to pay. Workers simply don't bother to recover their payment because the wages have been in arrears for too long, so the frontline workers suffer. At the public hearing, some people wanted to keep these conditional payment clauses, but then we have been through over 10 years of consultation. We've had many discussions. We urge the government to stand firm. We have the bill. Let's not make changes to it. Be firm when the government talks to different parties. Otherwise, we have a back door. We don't change anything. This bill already comes with an adjudication mechanism with payment deadlines. There will be changes to the ecosystem. Parties will get paid for the work that they do. That would be a major improvement from what we have now. So I urge the government to be firm. Let's not get sidetracked by other disputes, and that may end up holding us back. P.S. Thank you. The passage of this bill will offer stronger protection for workers to get paid for the work they do, because their employers will have an easier time getting paid. The bill is clear. Another tier party goes bankrupt. Still, the lower tier parties will not be able to rely on pay when paid clauses, and that's a key principle behind this bill. Thank you. Let me point this out. We now have pay when paid clauses. Those clauses will be banned in the future. But pay when paid, and that is paying wages when getting paid, is not a practice in the industry because employers have to pay their workers. It may happen sometimes, but it's not commonplace. Now, if members have no more questions about the policy matters, let's get into the clause-by-clause scrutiny. we have had a helpful discussion about the policy matters. At the public hearing, we have received great suggestions. We have had an ample discussion of those points. So now, let's refer to the Chinese text of the bill. Our legal advisor will look at the English text and feel free to raise any issue. The government has prepared slides to walk us through the overall bill. And then we delve into the clause-by-clause scrutiny. Members may refer to two documents. First, we have the Blue Bill, and that's LC paper number CP bracket 3392/2024. The Legal Services Division has also prepared the marked up copies, and that's CP bracket 1832/2024 bracket 02. Let's first hear from the government. Thank you. Now, the principles of this bill. Now, from our previous discussions, we know the bill is about payments in the construction sector. There will be mechanisms for the speedy resolution of payment disputes in the construction sector. In certain circumstances, a subcontractor can slow down or suspend work or suspend the provision of services and goods. There are also provisions for related matters. As you can see from this slide, there are 6 parts. Part 1, preliminary, with 3 divisions. So first we have the commencement date, interpretation, and also the scope. Part 2, payments, with 4 divisions. As we mentioned, there will be a 30-day window for payment responses and also a 60-day window for payment. We will ban pay when paid clauses. Part 3, adjudication mechanism. There will be 7 divisions. We will set out what payment disputes are, how a lower tier party can initiate an adjudication, how the adjudications will go, the powers of adjudicators, setting aside or enforcement of determinations, and also other matters of adjudications. Those will be covered under Part 3. Part 4, the right to delay work or supply. Those rights can be exercised in certain scenarios when payments are in arrears. Part 5 is on the administrative matters with 4 divisions. Division 2 under Part 5 will be on the powers of the Secretary for Development and also the ANBs. The last part or rather Division 2 under Part 5 will be about the right of appeal against the Secretary's decisions to the Administrative Appeals Board, with provisions on making amendments. The last part comes with 4 schedules. As we read out the clauses, we will brief members on each schedule. In short, Schedule 1. This was covered previously. We will exclude residential units in existing private residential buildings. We don't want to be disruptive to people. We strike a balance. Now, by residential units, we're talking about buildings for residential purposes. Now, there are units in guest houses and hotels. Those units are also built for residents. But those units are not places where payment disputes often arise, so this bill will not cover those residential units. We will expand on this point. Schedule 2 on specified structures. When we say construction, we're talking about work on these structures. Schedule 3. Specified entities. Now, Section 4 is on public contracts. We will be elaborating on this point. This means government, public bodies, etc. Schedule 4. Now, we will not cover construction projects with a lower contract sum. This is to avoid disproportionate administrative work. When we come to clauses 7 and 8, we will mention references to Schedule 4, that is, the contract value. Now, before we come to those clauses, let's first come to Part 1. Part 1 comes with 3 divisions. Division 1, short title and commencement. Now, this ordinance may be cited as the Construction Industry Security of Payment Ordinance. And then we also have the commencement date. Now let's look at Clause 1.3. Part of the bill will take effect on the date of gazettal. And that's 3A and 3B, interpretation, and also miscellaneous provisions. Those provisions empower the Secretary for Development and nominating bodies to do certain things. Those provisions will take effect right away. The related amendments will also take effect right away. Clause 1.2. The second commencement date will be 8 months after the gazettal. The remaining part of the bill will take effect from that date. That has to do with the adjudication processes. Two members are waiting to speak. Mr. Chen Xiuhong. My question has to do with Clause 1.2 and Clause 1.3. These two clauses are interrelated, but we haven't come to 1.3 yet. I believe we've all gone through those clauses. What I learned from previous meetings is that this bill will take effect in 2 phases. The point is to empower the Secretary for Development to engage or appoint nominating bodies. This will take 8 months. So the bill is gazetted, and then in the next 8 months, we will have the nominating bodies, we will have the adjudicators. And then the entire bill takes effect. Many people in the industry want to find out more. Now, before this bill is gazetted, the contracts won't be covered. But then a contract is entered into within the 8 months. And if a dispute arises in the meantime, the payment cannot be resolved under the new mechanism. If that dispute remains live after the 8-month window, will that dispute be covered by the new law?
Yes. Thank you, Chairman. Thank you, Mr. Chan. This is the purpose of the bill. So perhaps I'll take that question. Now, the bill will take effect, and then 8 months afterwards, the adjudication mechanism will come to play. And only contracts entered into 8 months after the Gazetto will be included. That means when you have a new contract entered into, as soon as the bill is gazetted, the contract is not covered. Only after 8 months, when you sign the new contract, will that be covered. So this is how the line is drawn. And meanwhile, we do discuss with the industry on how they should word their terms in the contract to facilitate the implementation of the new ordinance. So as I understand, it will take 8 months after the Gazetto, and that contracts entered into 8 months after the Gazetto will be included, but not before that, right? The next question about specified structures. I mean, Section 66 is accepted according to subclause 3. 66 refers to adjudicators. But since the adjudicators won't be ready at the time of Gazetto, it will be accepted. And then the next point is about Part 5. And I think this is rather clumsy. It refers to the powers of the Secretary. Now, in short, for some provisions, they come into effect on the date of Gazetto. And as for others, I think we need to hear from the administration when and how they will be effective. For some provisions, they come into operation right after Gazetto, but there are some provisions that won't come into operation until 8 months. I will come to that. Next, Mr. Lam Chun Sing. Thank you. Right, the first question is about commencement, and as the administration explained, some provisions will take effect 8 months after the Gazetto. However, the situation is really dire at the moment, and even for some major contractors or subcontractors, they may not hold on for 8 months. In fact, some contractors have urged the workers to stage a protest demanding payment. So meanwhile, what else can we do? I understand you're preparing to drop a list of adjudicators. Still, we have this window period of 8 months. Can you tell me what we can do? Because as far as the contract goes, the pay when paid clause will still be effective. So what can we do meanwhile? The next question is about residential units and the definition. I think the legal advisor asked a question, and according to the administration, is wholly or solely for human inhabitation. That's the administration's answer. What about composite buildings? There may be commercial operations in the unit, some sort of a workshop, and a major renovation of this place may involve a contract sum of more than 5 million. And at the same time, it's part of the unit is for domestic purposes. Right, I will come to that in a moment, so I'll save my question for now. You did ask this question on the 8-month window and what measures will be put in place to tackle the problem. PS. In fact, initially, we discussed with the industry and we proposed 12 months. They urged us to compress the time frame. Since then, we have mulled it over and we have decided to shorten the window period to 8 months. Well, we need to make efforts on training and on going through other steps. In fact, for the new contracts, we have included some pay protection clauses. For the upcoming projects, we are going to do the same. So as early as February next year, we will include the pay protection clauses that tally with the new bill in the new engineering contracts, so that we take a step ahead in complying with the new legislative requirements. As for the private sector, we will keep in close liaison with them to encourage them to meet the latest requirements. At the moment, when the works volume in the private sector is on the decline, we discuss with the sector on other matters such as cash flow as well. Mr. Andrew Lam. Coming back to the structure of this bill, I see that there are different parts to the bill, and an interpretation clause is included in the respective parts. My question is whether the interpretation clause only applies to that part. For example, in Part 2, right, Part 2. I'm sorry, let me go to that page first. Right, there is this definition of carried out in the interpretation of Part 2, but not in Part 1. I just want to know whether the definition applies to other parts as well. Right. Let's hear from the administration. Just very briefly, I'll say a few words and then I'll give the floor to my colleagues from the Department of Justice. In fact, for the interpretation clauses throughout the bill, they apply to the whole of the bill. There is a similar arrangement for other ordinances as well. The merit of adopting this approach is that for specific terms that often pops up in this part, we include the definition in the interpretation clause under that part for easy reference. I'll give the floor to my colleague. As you see, Clause 2 provides for interpretation. It sets out the definition of various terms that apply to all provisions in the bill. And then there are also interpretation clauses in respective parts, such as Clause 12, interpretation of Part 2. In this interpretation clause, the definition of the terms in this part are provided. So there may be some definitions in the interpretation clause that only apply to the part. So you see that in Clause 2, we have the interpretation clause, which applies to all provisions in the bill. And then in the respective parts, we also have respective interpretation clauses to deal with the definition of terms. So that's also the structure of different ordinances. We give a general interpretation clause, so to speak, at the beginning of an ordinance, the terms of which applies to the whole of the ordinance, and we also have respective interpretation clauses in different parts. Well, that's really a perfect answer from the PS. There may be terms that appear in the interpretation clauses subsequent to the interpretation clause in Part 1. And in any event, for the interpretation clause in Part 1, the definitions apply throughout the bill. Now, you gave a very technical answer, but from the public's perspective, my concern is whether there'll be a change in the meaning if there is an additional word such as carried out or carrying out. So from a layman's perspective, I just want to make sure that the interpretation clause applies throughout the bill. Now, my take is that the definition of terms are provided in the interpretation clause. It explains what the terms mean, but it's not a broad stroke definition. You mentioned the interpretation clause in Part 2 in Chinese 遵行 or in English carried out, and it's a very specific reference. If you find the same term in other provisions where there is possibly a conflict, we will then discuss the issue. But in fact, this is a frequent occurrence throughout the bill. I just want to set the record straight here so as to address the issue in one go. Yes. Let me supplement, as mentioned by my DOJ colleagues, there are interpretation clauses that apply to only the respective sections, such as in Part 2, Clause 12, carried out includes, except in paragraph B of the definition of billing date, undertaken to be carried out. So the meaning is quite specific. It refers also to undertaken to be carried out. So this explanation is quite unique to the provision in Part 2. Right, I quote this example because I'd like to refer to Part 1, 以進行 or have carried out or have undertaken to carry out. I just want to make sure that the same definition applies. P.S. I think we should go by the explanation given by the DOJ. If there is a specific reference in the interpretation of a certain part, then it applies only to the term in that part. Otherwise, if the same term appears in other clauses, then this definition in this clause does not apply. This is exactly why I raised this question. I think I understand now what they mean. Well, I had a similar question in relation to another bill, and my understanding is that for the interpretation clause under a certain part, the definition applies to the term in that part. Is not a general interpretation of the term for the whole of the bill. So if you see the same term coming up in other clauses, you should go by the general meaning instead of the specific definition provided in that interpretation clause. Mr. Louis Long? The legal advisor just reminded me to go through the long title as well, so we'll come to that in a moment. Mr. Louis Long. Sorry, I just It's a fat finger. I didn't want to ask a question. Right. Short title and commencement. Deputy Chair asked a question, and that is why, subject to subsection 3, the ordinance comes into operation on the expiry of 8 months after the Gazetto. That means the bill will come into effect on the date of the Gazetto, except for subsection 3, and it does not mean that means the bill should come into effect on the date of the Gazetto, except for certain provisions. Perhaps we'll come to that when we reach part 6. If there are no other questions, we'll now go back to the long title. Part 1, Division 1. I'm sorry, right, you asked about the long title. I read it out just now. A bill to facilitate the recovery of payments under construction contracts, to provide a mechanism for speedy resolution of payment disputes under certain construction contracts through adjudication proceedings, to give a right to a party to a construction contract under certain circumstances, to suspend or reduce the rate of progress of the construction work or the supply of related goods and services under the contract, and to provide for related matters. This is the long title. Any views? No? Please go on. We now go back to clause 1, subclause 3. For section 2 interpretation clause, it will come into effect on the date of Gazetto. That's 3A. For 3B, C, D, it relates to the powers and functions of the Secretary and they will come into effect in the second phase, that is 8 months after the date of Gazetto. Mr. Chan Siu-hong, Deputy Chair. I fully appreciate subclause 3, which relates to a phased approach. We need to empower the Secretary to appoint the nominating bodies and prepare a list of adjudicators. And yet for 3C, it says, except section 66 is understandable because, well, we'll come to that part very soon, but it's about adjudicators, not compellable witnesses. Let's say within the 8-month period, you prepare a list of adjudicators, but they are not yet ready to perform the functions, and that's the rationale behind exempting section 66. What about the other clause? It's about the adjudicator fulfilling certain civil obligations. Why don't you exempt the same? For section 66C is any dispute resolution proceedings. Perhaps it should be put under Part 3, Division 7. What's the rationale of including that in Part 5, Division 2 instead of Part 3, which relates to the everything about adjudication? Because in your drafting, it sounds rather cumbersome. Divisions 1, 2, 4, 5 of Part 5, except Section 66.
多謝議員。
Yes, administration. Thank you. Section 66 is about exempting adjudicators from certain civil obligations. And Section 66 refers to specifically the procedures. Section 65 is, as I said earlier, about immunity from civil liability, and it relates to section 3. That's why we put it in subclause 3. As for other liability provisions, they are found in Part 5. We have discussed this with the government councils, and we believe it is appropriate to include them in Part 5. I want to ask about regarding brackets 1 in Section 65, that is, an adjudicator is not civilly liable for an act done by the adjudicator. So the adjudicators may be included in a list, but they cannot really do anything. What's the point of enforcing Section 65 then? I don't really understand. Well, I think what they meant was because there is really no need for this immunity clause to come into effect later. So they have made it to come into operation right away. I'll let the administration explain further. Mr. Salvador Zhang, thank you. Well, in Part 3, there are multiple provisions in relation to the powers of the Secretary. In particular, Section 66 is about after a determination has been reached, whether an adjudicator can be compelled to become a witness in other civil proceedings. Because in the 8 months we will not have a determination, there is no need for Section 66 to come into effect. In Section 65, there are the subclauses, for example, subclause 2 and 3, that are about the secretary or a public officer as well as the government. In subclause 1 in particular, it involves not only the educators but also bodies, as the bodies will operate within the 8 months, so this would be relevant in the 8 months. That's why it has to come into effect when the bill is gazetted. It may be hard for us to make the operations phase for this section in particular, and it will not facilitate readers' understanding. Regarding the miscellaneous provisions relating to liability, usually we would include this at the end of ordinances. That's why we have included them in Part 5 to deal with the specific processes in Section 65 and 66. We do understand the members' concerns about it being somewhat confusing, but we believe the structure will be more coherent in this manner. Thank you. Any other questions? No? Thank you. Please proceed. Thank you. We'll move on to Clause 2, interpretation. There are 2 subclauses, so subclause 1 would point to the references, and we will talk about the specifics when we get to the clauses. We want to discuss these when we get to the specific clauses because we think it may be confusing without context. So we will look at this subclause as well as the next subclause when we get to the specific clauses. Sure, please proceed. Thank you. Now we're at Clause 3. That is page C1557, meaning of construction work. So construction work is defined in the ordinance as some basic concept. So there are two major categories: one, new works, and the other RMAA works that would be more like rehabilitation works. And they are set out in A and B of subclause 1. In subclause 1A, it mentions specified structure. And we can find the specific definition in C1681. In C1681, there are 15 specified structures. And when we get to section 16.9, it actually says that we have the power to make amendments to the schedule if necessary. Excuse me, please pause here. We have questions from members. We'll first have Mr. Chen Siu-hung, the Deputy Chairman, speak. Thank you. I have a question about the definition of construction site in clause 2, as well as the definition of construction work. We have more MIC projects now. So the definition of construction sites should not include only the sites in Hong Kong. It should include the sites of assembling in Zhuhai, for example. Are we going to include these sites? Or do we only include construction sites in Hong Kong? We do not include the sites of assembling in the mainland. Next, the components would have to be transported to Hong Kong for specific assembling in Hong Kong. So I want to know whether the construction sites definition has considered this. Thank you, administration. Thank you. The question is about a definition. In general, this definition or the ordinance would be applicable to projects in Hong Kong, but it can include contracts of overseas goods and services. So even if it is an MIC project for a contract of the components of MIC, it can still be covered. So the ordinance is not applicable to projects outside Hong Kong, but now we have a more complex issue where certain components are manufactured outside Hong Kong. How will we determine the coverage? And how are we going to make a distinction here? Permanent Secretary. Thank you. In general, if we are constructing a bridge in Hong Kong, if the bridge is in Hong Kong, this project will be covered. Also, if we construct a building in Hong Kong, the project will be covered. The building project may have components or modules from different places. The contracts under the project would still be covered, even if the components come from overseas. Thank you. All right, thank you. Mr. Tony Tse. Thank you. As Mr. Chen Siu-hung pointed out, there is some confusion about the definitions. For clause 3.1 in particular, it details the meaning of construction work, and they have two categories set out in A and B. So in B, they talk about replacement, extension, renewal, alteration, repair, restoration, maintenance, dismantling or demolition of or the addition to an existing specified structure. I believe there is a definition for specified structures, and they have 15 types of structures specified in Schedule 2, and it is said earlier the schedule can be amended if necessary. I think Schedule 2 is quite detailed. I believe you're trying to be comprehensive here, right? Of course, we don't want to amend the schedule frequently. So I want to ask, is it the case that you do not have any plans to amend Schedule 2 anytime soon, right? Because you have been quite comprehensive when drawing up Schedule 2. I want to get a response from the administration for this right at this moment before I ask any other questions. Thank you. Thank you. Administration, please. Thank you. Well, the 15 categories are the general categories of structures that we can find in Hong Kong. It covers different areas such as E&M installations, buildings, and whatnot. We have been quite comprehensive. I do not rule out the possibility of making amendments to Schedule 2, but I think there is no immediate need to amend the schedule anytime soon. If any amendments are to be made, they will be done through negative vetting. Well, I think indeed the schedule has been quite comprehensive. Should something happen, I think paragraph 15 of the schedule should cover the exceptions, because here it says any other building or structure. So I think it should cover everything. Chair, I understand that the schedule is already quite comprehensive, but should there be a structure that is not covered under the schedule, they will not be excluded altogether in the ordinance, right? Or they will be. So that's why we should be as comprehensive as possible. Administration, thank you. Well, we have tried to be as comprehensive as possible, and the schedule covers in general all the projects that we can see in Hong Kong. Mr. Chen Siu-hong. Thank you. I want to ask about Part 1, Division 9. In fact, I have an observation in that clause. Perhaps I will ask for a clarification when we get to this specific clause or clauses. My understanding is the same as that of Mr. Chen Siu-hong, so I would like to seek some clarifications when I get to that specific part. Thank you. All right, please proceed. Subclause 2 of Clause 3 sets out the works to be included without limiting subsection 1. In A, it is said that work that is carried out to an integral or ancillary part of a specified structure will be included, including the 4 subcategories set out in A. And in B, work that is preparatory to or for rendering complete any work mentioned in the subsection that would include the 4 major categories set out below. Mr. Andrew Lam. Yes. Thank you. Again, I would have questions later, because from what the principal assistant secretary said, often we understand that work that is carried out to specified structures will be included, but then landscaping works may not be considered as works to the specific building. For example, it may only be undertaken in a lawn. So how is it the case that it will be covered? Yes, administration. Thank you. When we talk about landscaping works being covered, how it is included in works being carried out to a specified structure, as long as it is carried out to an integral or ancillary part of a specified structure, landscaping works will be covered. So this will be this scenario where landscaping works will be covered. Well, I think in English it's actually quite clear. There may be a discrepancy in the Chinese and English versions. I want to say this. In landscaping works, it may be different. I think we can talk about the specifics when we get to that part. I would just like to note that I have my concerns about this. Well, let me say this. In a project, often there are landscaping works, and I think we should take the perspective of, in such case, it should be included. For example, under a construction contract, if it includes the planting of trees, then this should be covered. All right, we'll have Mr. Lai Tong Kwok speak next. Thank you. I want to ask about subclause 2 of clause 3. In subclause 2, it has essentially extended what is said in subclause 1. So that's why they mentioned in that subsection, that is subsection 1. But you're saying at the very beginning of the subclause that this has to be done without limiting subsection 1. I don't really understand why you included this expression here. In subclause 3, you have defined utilities and services installation. You did not say in subclause 3 that you would implement this subsection without limiting subsections 1 or 2. This is somewhat confusing. Are you sure that readers won't be confused in future when reading the ordinance? Thank you. Administration, thank you. I will invite the DOJ colleague to talk about specifically why without limiting subsection 1 is included in subclause 2. Yes, thank you. Why we included the expression in subclause 2? Well, in fact, this expression is commonly found in the ordinances in Hong Kong. In subclause 1, we actually had a meaning of construction work included, and we have specified in subclause 2 what the works would include, but we want to make sure the specific works, the specific categories of works included in subclause 2 would not limit the usage of subclause 1. So this is why we included the expression.
So clause 3.1 we have a broad definition of construction work, and then clause 3.2, we get examples. So is that the idea? Yes? So 3.2 is about examples of 3.1. So 3.2 is not being exhaustive, and that's why it does not restrict the meaning of 3.1. Mr. Chen Xiu-hong. Two questions. Those questions were raised by Mr. Lai Tong-kwok and Mr. Andrew Lam. Landscaping in English is clear enough, but the Chinese rendering 遠景建構, can it be improved? Can we phrase it differently? The current Chinese phrasing is hard to follow. There are different kinds of services involved in landscaping, after all. So can the Department of Justice rethink the Chinese phrasing for landscaping? Mr. Lai Tong-kwok has a point about this question without limiting subsection 1, and then we heard the response from the DOJ. I get the point, but here's my question. We're defining construction work here. We say we're not limiting subsection 1, and then we set out examples. But here, the phrasing is odd because it says without limiting subsection 1. Now, BIM is involved in some subcontracts building information modeling. Software is involved. That has nothing to do with the work site, but the service is provided. How does it fit into this clause? Is it under 3.1 or 3.2? Can we invite the PS to explain this? Now, the Chinese phrasing for landscaping, 遠景建構. Now, people may wonder whether it has to do with hardware. The English phrase is clear. Landscaping, it covers hardware, software, everything. I will invite my DOJ colleague to tell us more about why we phrase this term this way in Chinese in a moment. Now, on the phrase without limiting subsection 1, my colleague has explained that firm, so maybe I will invite my colleague from the DOJ to tell us more. Mr. Salvador Zhang, or rather, Ms. Annette Lai. Landscaping as a phrase comes up in other ordinances too. The Chinese rendering is also 遠景建構 in those ordinances. CAP 587, and that's a Construction Industry Council ordinance. Landscaping also shows up there, so we modeled our phrasing here on CAP 587. So that's current usage in other laws. But what about BIM? Which group does it fall under? Clause 3 is about the construction work. The services are covered by other ordinances. So services such as BIM are covered elsewhere. Consultancy work is also covered. Here, this clause is about the construction work, what we mean by it. Clause 3 is about the meaning of construction work. Of course, construction contracts cover both hardware and software. BIM is involved. And then site management is also covered under contract. Disputes may arise over those matters too. Those things can happen. Those things may feature in the construction contract. Chairman, it matters what we cover in this bill. Some work is done outside Hong Kong. Restricting the scope to a work site in Hong Kong may cause issues. A contract may involve work exclusively outside Hong Kong, and then those modules are carried to Hong Kong. Scenarios may vary. Let's delve into this when we get to clause 9. So can we get the PS to develop this point? Say we go for MIC. Modules are involved, but then you may have a contract about making those modules for MIC. The company is based in Hong Kong, but the making happens in the mainland. In that case, does that contract get covered by this bill? PS, please. I'm grateful for this opportunity to clarify this point. Now we are talking about the scope of this bill. Now here we are talking about where the structure is. It has to be a structure in Hong Kong. Say you build a building in the mainland, that's outside the scope here. That has to be a building in Hong Kong. Now, in MIC, say we have a module made in the mainland, but the assembling and the building happens in Hong Kong. It's for a building in Hong Kong. In that case, that project will be covered by this bill. So when you have a contract that's for the construction of a building in Hong Kong, that contract will be covered by this bill. So that's to clarify the point. So you may have BIM, the work is done in Singapore, the software is made there. But once that service is for a building project in Hong Kong, that contract will be covered by this bill. Let's move on. So that's for clause 3. Clause 4, that's C1561 in the English version. Meanings of public contract and main private contract. Now we're talking about the top level contract. So clause 41A, we have to explain owners. Now we've explained this point elsewhere. By owner, we're talking about the top tier party. Now under clause 2, we're talking about owners who hire others for the supply of related goods. An owner is not engaged by another person to carry out the construction work or supply related goods and services. So first we define the owner. Now moving back to clause 41B. What we mean by public contract and main private contract. So when one owner is the owner, B1, now when the owner is a specified entity, the government or one of those specified entities in Schedule 3, in that case, the contract is a public contract. The definition will have a bearing in helping us tell whether a contract is within the scope of the future ordinance. This distinction matters when it comes to resolving the payment disputes, we have to distinguish between public and private contract. So once you meet the criteria here, you have a public contract. Mr. Tony Tse and Mr. Chen Xiu-hong. Mr. Tony Tse. Can we get more clarity on this point? So you sign the contract, you become the owner. You have a party signing that construction contract. But then you also have a party owning the property. How do you tell the difference between those parties? Do we just look at the party signing that contract and we refer to that party as the owner? Or do we have a separate definition? Now we will have specified entities. We will have a list, and that's in Schedule 3. So how do we tell whether a body falls under Schedule 3? Of course, you may add organizations to Schedule 3. And we may have more universities over time, for example. So can we get more clarity here? So do we make a distinction between who owns the property and who signs the contract? P.S. First, public contract. We want to take a contract as a starting point, and then from that point onwards, you have subcontracts. Those subcontracts fall under this bill. You look at the main contract, the client signs that contract with the main contractor. Schedule 3 sets out public bodies, the airport authority, the housing authority. Schedule 3 also covers public utilities firms. Those companies sign the main contract with the contractors. We have to make a contract the starting point, and then all subsequent subcontracts will be governed by the bill. Schedule 3 pretty much covers or mostly the subvented companies, subvented corporations, public utilities companies. Those companies have many works projects. Those corporations have a duty to ensure fair payment terms. So we put those bodies on the list of specified entities. Now we have talked to those bodies. Chairman, I think the PS made 3 points, so those bodies have to be funded by public money. That's the first point. The second point, it has to be a body owned by a government department, or 3 public utilities companies. So are those principles we follow in deciding what we include in Schedule 3? There has to be some sort of principle you follow when you make Schedule 3. Now my other point was say you have the Urban Renewal Authority. The URA, in undertaking project, works with developers. So in such a case, now when the URA signs the contract, that contract becomes a public contract. But the partner developer, where does it fit in? For Schedule 3, those are statutory or public bodies. Those are bodies owned or funded by the government. They also include public utilities firms. Schedule 3 covers bodies that have works project day in, day out. The member's other question has to do with the URA. The URA signs contracts with developers. Do those contracts count as public contracts? Now let's look at C1551, construction contract. We're focusing on the construction contract. Say a URA signs a contract with developers. Those contracts are out of scope. I thank the PS for the explanation. Those contracts involve partnerships over a building, but those contracts will not be covered by this bill. But then a main contractor is involved. For a contract to be covered by this bill, the URA has to be the party signing the contract with the main contractors. Otherwise, say when you have the developer sign the contract with the main contractor, that contract won't be a public contract. Because in that case, the main contract will be involving exclusively private developers. So when the URA is one of the parties signing the contract, that contract will be a public contract. Now this session will last up to 10:30. We're at 10:28. Mr. Chen Xiu-hong is waiting to speak. So let's save your question for 10:45. Let's pick up at 10:45. Thank you.